hearing in the Tata-Mistry case is taking place on the cornerstones of probity and what both sides feel as legitimate expectations. The CJI observed that a person once wrote to a judge stating that he should be made the CJI just because he feels that it's a legitimate expectation, over which the CJI gave an example of Lord Krishna explaining to Arjun the futility of expectations in the long run. The CJI questioned whether any claim for valuation was also accompanied by a report of the valuation, and this is something which both the sides are contesting as of now. The CJI also questioned Tata Group's lawyer whether they feel that the tribunal should have pointed out losses whose burden fell only on minority stakeholders. Also, the CJI observed that many challenges come up to legislations and are often mixed up with the powers which are exercised with respect to the legislations does not mean that the legislation itself is bad. The CJI also observed that it was for the court to decide whether it was just an equitable to wind up a company. He also criticized use of the word technical by lawyers, claiming that the word technical is used to water down accuracy in pleadings, and if one does not adhere to technique, non-compliance with any order of legislature or court cannot be merely deemed as technical. The CJI asked Salve to answer on the use of the word technical and made it clear that everything cannot be covered under the word technical and dismissed. CJI asked Salve whether ROC felt castigated for calling the company private in writing, over which Salve answered in the affirmative. CJI has also asked Mistry's lawyers if they want to clarify on the aspect of ROC's role, over which Arama Sundaram has submitted that there are various details they would like to submit, and factually events may have been quoted as correct but the interpretation is wrong, over which CJI has asked both the sides to give a list of dates which will also include the list given by both the sides in this regard. Harish Salve had submitted that NCLAT had picked up points from written submissions given by SP Group and had passed an order without even specifying what was wrong with NCLT order. Also, he submitted that companies have full right to give discounts and this does not qualify as lack of probity. He was referring to certain objections which were raised by the Shapoorji Pallonji group over various perks and incentives which were given to various senior members of the Tata Group. He also submitted that all claims were rumbled up together, be it the claims of being prejudicial, oppressive and mismanagement. The hearing in this case is going to continue tomorrow.